Hello, Mallory. Is everyone that's calling in able to hear now?
Yes, I believe so.
All right. So if there's anyone out there with the Judicial Department that has called in and cannot hear, I'm available by the Oregon Judicial Department chat. So feel free, this is Becky Orr, to send me a chat. As I said, this is Rebecca or Becky Orr. And for those of you I don't know, I am a retired circuit court judge and currently working half-time for the Judicial Department under a Federal Violence Against Women Act grant, dealing with issues concerning domestic and sexual violence, elder and disabled abuse, and civil stalking matters. And it's my pleasure today to welcome all of you to the webinar. All right, I just got an email from someone saying they can't see the webinar, so I think what I will just say to everyone, you have to click on the link in the email meeting reminder you were sent, and then actually register your name, I believe, and then you should connect. So I will come back to that. It is my pleasure today to introduce our speakers. The first of our speakers that I'll introduce is our Honorable Amy Holms-Hehn, who is a Multnomah County, Oregon Circuit Court judge handling family law matters, including domestic violence, probate, and juvenile cases. A native Oregonian, Judge Holms-Hehn was appointed to the bench in January of 2013. Before her appointment, she served for 25 years as a deputy district attorney in the Multnomah County DA's office, including the senior deputy of the juvenile and domestic violence units. She has a long history of involvement in domestic violence, juvenile justice, and child welfare system improvement efforts on the local, state, and national level.
Hello, everybody. Just say hi. This is Judge Holmes-Hehn.
The Honorable Lynn Tepper is our other judge presenter today. Judge Tepper has been a circuit judge in Florida's 6th Judicial Circuit since 1989. She sits in the Dade City Court presiding over all the dependency children and families in need of services and crossover cases for the families before her, as well as all the domestic violence injunction cases in East Pasco County. Her court is one of 6 sites in the United States that's implementing Project One, which is a project of the National Council of Juvenile and Family Court Judges that addresses one family, one judge in their program. However, Judge Tepper presided over the Unified Family Court in 2001 in Dade City that was funded by a Florida Supreme Court grant, and has been informally practicing one judge, one family for a decade before that. She served in virtually every Florida Bar Supreme Court committee involved with children, families, and domestic violence, and led the Governor's Domestic Violence Clemency Review panels. Judge Tepper has received numerous awards throughout her career and also teaches and speaks nationally and statewide on topics ranging from dependency to abuse and human trafficking. Our third speaker is Malore Dusenbery, who has served as the Associate Director of the Economic Security for Survivors Project since 2012, where she provides resources, training, and technical assistance to service providers, the justice system, and policymakers to improve the economic security and safety of survivors. Her particular focus is on criminal justice system interventions that support survivors' needs and offender accountability. In addition to working for both the nonprofit Wider Opportunities for Women's Policy and Research departments, Ms. Dusenbery has also advocated for justice system-involved abused girls and youth sex trafficking victims, developed and presented teen dating violence prevention programs, and evaluated local sexual assault prevention programs. So without further ado, I'm going to turn this over to Mallory.
Great. Thank you so much, Becky. And hello, everyone. We're so glad to have you here today. Just a few quick text notes before we dive into the content. If you have any questions for the presenters or any tech issues, please use the chat box in the lower left corner of your screen to message either myself or our chairperson, who is Sarah Gonzalez-Basinski. For technical support, you can also call ReadyTalk at 800-843-9166. Due to our limited time today, there may not be enough time for questions or comments at the end, but if your questions haven't been addressed throughout the course of the discussion, we do encourage you to contact us following the event. Now I'm going to briefly discuss the links between economic security and victim safety before turning it over to our esteemed judges for the bulk of the discussion. Previously, with wider opportunities for women and soon to be housed within the Institute for Women's Policy Research, the S Project is funded by OVW to provide training and technical assistance to groups working with survivors of intimate partner violence, sexual assault, and stalking around issues of economic security and safety. The goal is to ensure that survivors may be safer, better able to recover from violence and achieve independence, and better able to pursue justice. So in addition to direct service providers and community institutions, we work with criminal justice professionals to reduce barriers to accessing and participating in the justice system, restore victims economically for the harms caused by crimes, and hold offenders fully accountable. So there are three main ways that we see economic insecurity and violence linked, all of which can intersect and compound upon one another. First, economic insecurity and poverty can keep victims trapped in abusive relationships for longer because they lack the resources to leave and thrive on their own. They may be unable to obtain medical care, secure housing, child care and transportation, or take time off work to access the justice system. According to a 2012 survey of domestic violence shelters, 74% of victims stayed with an abuser longer because of financial reasons. And the longer that they stay, the more at risk they are of violence, of the economic consequences of that violence, and economic abuse by the offender as a tool of power and control, which are the other two ways that we see violence and economics linked, which I'll talk about in just a minute. But first, just to illustrate the extent of economic insecurity and the barriers that victims face from economic insecurity, here are the actual very minimum cost of living for a single parent with one preschooler for various counties in Oregon based on research conducted by Wider Opportunities for Women. These numbers, as you can see, are much higher than the Oregon minimum wage, and the largest categories tend to be housing, transportation, and child care, which we also see as the biggest barriers cited by survivors when making decisions about escaping abuse. So when making these calculations about the cost of housing and child care, many survivors find they can't afford independence, especially if they're in low-wage work or unemployed due to the abuser's actions. And I should note for anybody in Multnomah County, for that number, when considering the county without Portland, the annual total actually jumped to over $53,000 a year because of the lack of public transportation and higher taxes. So the basic economic security tables, or BEST, which is where these numbers come from, are available for free online for 420 different family types and for every county. So please feel free to look up your jurisdiction if it's not included here. And by comparing the national BEST numbers with actual labor market data, it's clear that at 60%, women are much more economically insecure than men, and that women of color even more so, with insecurity rates approaching 80%. This corresponds with what we know about who is most vulnerable and at the greatest risk for these crimes that we're talking about today. Being economically insecure generally means lacking any savings for an emergency, which we know is essential for survivors to weather the costs incurred by the violence against them. And furthermore, women of color face additional barriers to accessing resources and the justice system that makes it even more difficult to escape the cycle of economic insecurity and abuse. So now back to the impact of violence that I mentioned before. There are similar and distinct economic impacts, whether you're a survivor of intimate partner violence, sexual assault, or stalking. We also know that these crimes often co-occur, which compounds the cost. For example, the average medical cost for physically abused women was $483 per incident and $207 for mental health services. And we all know that most victims experience many incidences before they're actually able to escape abuse. Survivors also experience a 50 to 70% increase in gynecological, neurological, and stress-related problems that continue long after the last incident. In terms of employment, survivors lose many days of work a year, ranging from 7 for domestic violence to 8 for sexual assault and 10 for stalking, either from an offender's intentional actions or as a result of survivors having to take time off to recover, obtain health care, or seek justice. And missing work may lead to missed promotions or even job termination. Studies find that anywhere from 24 to 60% of survivors have reported being asked to resign or fired as a result of abuse. There are also significant impacts related to violence or stalking when it comes to housing. 28% of housing denial cases involved domestic violence victims who were denied housing because of the violence against them. And they may face eviction if law enforcement is called to their home, or they may have to pay to have locks changed, windows repaired, and security measures installed. And this is beyond the cost of having to find new safe housing on their own, which we saw from the best numbers can be very difficult. In terms of education, grades may suffer, and they may actually lead to higher rates of dropping out or lost scholarships. And there are also impacts related to repairing property and repairing debt or damaged credit. And in addition to all of these, survivors must navigate additional economic barriers and costs related to the justice system itself. There are high costs associated with participating in this system, in addition to court fees, attorney costs, and lastly, survivors may fear consequences from their own involvement in the system, either through dual arrest or for arrest of crimes coerced by the abuser. And this is just a snapshot. So in addition to the unanticipated costs, many abusers intentionally target a victim's economic stability to create dependence and maintain power and control. Economic abuse is defined as when an abuser makes or attempts to make an individual financially dependent by maintaining total control over financial resources, withholding one's access to money, or forbidding one's attendance at school or holding a job. The tactics abusers use generally fall into these 3 categories: economic sabotage, economic control, and economic exploitation. There's a lack of data on the full extent and impact, but the available research we do have shows that economic abuse is very pervasive. Domestic violence programs in 10 states reported that 88% of abusers controlled all finances and 73% of abusers directly stole money. And a study evaluating the scale of economic abuse found that 99% of participants experienced some form of economic abuse. Looking at the different forms of economic abuse, you may have noticed that many of these are actually crimes in and of themselves, such as theft, fraud, identity theft, and destruction of property. These can and should be charged as separate crimes, may even be easier to prove, and can provide the basis for essential economic relief. The prevalence of these abuses, as well as their connection to criminal activity, makes it extremely relevant for the justice system in general and the court specifically to address. Each of these factors, independently or in combination, significantly affects a victim's decisions about leaving an abuser, their behavior when involved in the justice system, such as their participation, testimony, and requests, and ultimately their overall short and long-term safety. So with that, let's dive into the role of the judiciary in addressing these issues and hear from our 2 excellent judges, starting with Judge Holms-Hehn.
Hi, thank you. Thanks, Malore. So there are a number of ways in which a judge might be in a position of issuing orders that impact victim economic security. So we'll be talking about some of those in a moment. But I think Judge Tepper and I wanted to make a few preliminary comments. Judges are sometimes reluctant to advocate for processes and procedures that support and assist victims. I think they fear that it can create the appearance of a lack of neutrality, especially in criminal cases. And so it can be controversial for judges to participate in the improvement of processes focused specifically on victim access to justice and the enforcement of victims' rights. My view, and I think the view of many judges, is that we are called upon to enforce all of the laws and the provisions of the Constitution, and victims' rights are enshrined both in Oregon statute, in case law, and in the Oregon Constitution. And my view is that ensuring that victims' rights are enforced should not be viewed as bias or impartiality. It's part of our job to enforce all the laws to ensure that everyone's rights are protected. That said, defense attorneys don't always see it that way, and so it's important to think carefully about what you say and how you say it about the rights of victims, because while we may feel that we're taking a stand that we're required to take by law, it can be viewed as something that defense attorneys feel puts their client at a disadvantage, and so you can draw affidavits and other challenges. But my view is we really need to ensure access to justice for all, both defendants and victims. Judge Tepper, did you want to comment on that further?
Yes, I wanted to add that how we phrase it can be very important. I do think that whatever we do in impacting the economic or minimizing the economic impact on a victim, we actually can make it palatable for whether it's a defendant in a criminal case, it's a partner or a parent in a family law case, an injunctive case. If we can phrase it so that, and under Florida law it's specifically set forth, that if there is, for instance, an opportunity to commend somebody for doing what they were supposed to do, you can start to shorten probation. You can start to loosen up some provisions. So when we set out our conditions, we want to make sure that we don't have indirect negative impact economically on the victim, allowing them to go to workplace and things like that. But likewise, if we have a criminal case with restitution and we've set out very specific manageable orders that have input from the defendant, is there any reason you can't pay X number of dollars by such and such a time? We've given them a guidance. We've given probation a guidance. And we've also said, and when should you finish it early, I'll consider having you come back and ending this. That makes it palatable for both. It makes it safer, and it helps make a victim whole. That's just the overlook for now.
Yeah, agreed. So just backing up a bit, so we're going to talk about some of the specific realms in which economic justice for victims might be present. So, for example, obviously, in criminal cases, the court may be called upon to order the payment of restitution or probation conditions which bar the defendant from doing things that might have a negative economic impact on the victim or impair her security through economic coercion or manipulation. Also, there are sometimes civil lawsuits brought on behalf of victims, independent of a criminal prosecution altogether. In family law cases, economics are very much an issue in both custody and parenting time cases and dissolutions. So issues of economic abuse, if you will, in those realms must be identified and addressed by the court. We're going to turn more specifically to some of those realms and start with talking about addressing economic security in the criminal justice system. So, Lynn, do you want to take a lead on that and talk about how things work in your corner of the country?
And some of this it will relate to Oregon and other places, but let me say that in terms of the benefit to the system, one of the best things that can happen is to the extent that judges get involved in educating prosecutors, defense attorneys, parole and probation, and law enforcement. The case can be made to protect the likelihood that a victim is going to be made whole, presuming there is a conviction, a likelihood the victim will participate in the process instead of somebody's arrested, they don't participate for all of the economic reasons we might touch upon, and the case is dropped, but then you'll see them back 3 more times. And then you're going to see them in family court because then they have children or whatever, whether they're strangers or they have a relationship. If up front we can be sure that referrals are being made either by the court when we first see them or law enforcement has been trained for crimes compensation, local community resources that can assist, making sure that if they go to the clerk's office because they want a civil injunction, they have all of the information available. Law enforcement. In Florida, by statute, all of these systems are required to be aware and direct a victim to resources in the community. And, of course, I think it's very important that we remove the opportunity for an offender, a respondent in an injunction, a non-custodial parent, whatever, to not be able to blame the victim. In other words, if the court does its job or probation does its job, whoever is responsible, including the court, for assuring that our orders are actually followed, that will assist in taking the blame off of the victim. They shouldn't have to be begging or having third parties beg the person to pay restitution. And once the policies are made up front and clear, then everybody knows that they can expect compliance and that there'll be impact if they don't. just setting the stage to show that we're going to be fair and just to both sides and that our orders expect to be followed.
So talking about restitution in the criminal system, as Judge Tepper has touched on, we know that the legal authority to order restitution is found in ORS 137-106, but the right to prompt payment of restitution is also a core victim's right enshrined in both statutory and constitutional law in Oregon. And so the court is required to order restitution if requested by the victim, and the connection between the criminal conduct and the loss suffered by the victim can be established. Judge Orff shared a good summary of some recent cases on restitution, which I would urge you all to have a look at. Important to know about a recent case which does change the playing field a little bit, and I'm referring to State v. McClelland, which is 278 Oregon App 133. And so that case stands for the proposition that bills alone, so we'll say bills for medical treatment as was in that particular case, don't alone establish the reasonableness of the amount of restitution being requested. So there's sort of a new piece that the state or advocate for the victim has to be prepared to prove, which is the reasonableness of the request for restitution. As a practical matter, most of these cases will be resolved, or most of these issues will be resolved through plea negotiations with the defense stipulating to reasonableness. But in the context of a contested hearing on restitution, that additional element needs to be proven. The Pumphrey case, which Judge Orff supplied, is a good summary of the law of restitution in Oregon. Now, as far as how restitution orders in probation cases are enforced, certainly a failure to pay restitution as required by the court would be a probation violation if the orders are specific enough to require the payment to be made in such a way that the defendant has noticed that if they don't pay on time or in a certain amount, then they're in contempt of the judge's probation order. But I'm interested, Judge Tepper shared with us a different process, or a more complex process that you use in your jurisdiction with detailed orders and regular reviews. Do you want to talk about that, Judge Tepper?
I'm happy, if anybody is interested in the orders that arise based on Florida law, to share them. But our statute permits a lot of things, but I decided to clarify it by separate orders. Our statute allows, by the way, an income deduction order, and it's not unusual for me to enter an income deduction order. And it's enforceable, and I can direct where it's going to be paid, whether it's going to be paid through probation or paid through the clerk. And I try to, again, I have input. I ask before I issue the order, how much do you think you can pay a month? All right, let's calculate how much it is. How many months probation, therefore, are we going to put you on so that you can finish this 60 days prior to the end? And this is all set out in the order as to when they start, who they pay, what address they pay. And I may even set what's known as a judicial review, and I can do that in delinquency cases as well as in state cases, so that we have a restitution order that's clear, we have a finding of what is and isn't going to be covered, and we have a date to come back to make sure it's working. That way, we are holding we have accountability. But in addition, we don't want to set somebody up for failure, and we don't want indirect impact upon a victim who isn't getting the restitution that they need to keep their job, to do their life that they had before this criminal act occurred. In delinquency, we also have a statute that allows me to bring them back in at any time. Also, in our Florida law, the court retains jurisdiction for 5 years after somebody is even released from prison, or if not on this charge, on another charge, until they get out of prison. And it's enforceable as a lien. And we will periodically have a defense attorney come in and say, could we please convert it to a lien, Judge? But as long as everybody understands and the forms help make it clear, I find it's easier to enforce, and you're more likely to get payment. And our clerk, I will order a printout every 3 months of the status of restitution, so I can see whether I need to bring somebody in because they're not paying.
I'd say that my experience has been, it's been a challenge historically to have the Department of Community Justice on both the adult and the juvenile side here make payment of restitution a priority. And so I think that progress is being made on that front here, but often restitution is kind of the last thing that POs are thinking about when they're working with the defendant.
to interrupt, I require that I will, for instance, waive the cost of supervision for 60 or 90 days, and to the extent that under Florida law they're permitted to do community service in lieu of paying court costs, I will do that, and I mandate that restitution be the first matter that's paid, not cost of supervision.
Yeah. Another way this comes up is for termination of probation. Sometimes POs will request early termination of probation when there's or allow probation to lapse when there's outstanding unpaid restitution. And so in my mind, we as judges should resist those types of requests because I don't believe that we are adhering to our constitutional obligation to ensure that restitution is paid to victims if we're allowing that to happen. And so I would urge that we have hearings as probation is winding down to check on the restitution issue and to not allow it to terminate until restitution has been paid absent exceptional circumstances, and victims should have input in those hearings.
One of the safeguards that I discovered over my 31 years of doing this is if I say it must be paid in full by, and I had consulted with parole and probation, how much time do you need to get an affidavit in of violation, and I say 60 days prior to the end. That gives them time to keep jurisdiction by filing the affidavit so you can have the arrest, whether you want your arrest to say cash only on the equivalent amount of restitution, but so it's not just abandoned.
Right, and it's not just vague as to when the person is supposed to pay, because that's not really an enforceable order against the person. It's just some general, you got to pay it, and there's no structure around that. So let's turn now to some other contexts in which the issue of economic security for victims comes up. And one is in the realm of Family Abuse Prevention Act restraining orders. Oregon law does allow the court to order, if requested by the petitioner, emergency monetary assistance. And that relief has to relate to both the safety and welfare of the petitioner. And in Oregon, that's a one-time payment. It's not ongoing support. And Judge Tepper will talk in a minute about how that's handled in her jurisdiction. But Oregon made a specific decision not to allow for child support as part of a Family Abuse Prevention Act restraining order process. And there were a bunch of reasons why that were presented to the legislature. And I won't go into a lot of detail about that. It's just simply not the law in Oregon. But I would say that the issue of emergency monetary assistance is controversial among judges. It's controversial among judges in Multnomah County, and I assume it's controversial across the state about what constitutes the kind of issue that would impact both victim safety and welfare such that an order of emergency monetary assistance is appropriate. Another thing about it is that the respondent can't be required to pay. Payment is not due until 45 days after the restraining order is issued. So it's really not an emergency response because there's going to be over a month before the respondent is actually required to pay, although some respondents do pay. So, the judges who order it are of the view that, look, a lot of these guys or women will pay, and so that's helpful to the victim. But other issues of controversy about which judges disagree is some feel that there's a due process issue with entering a money order without the respondent present to be heard on that, and without any information often about the respondent's ability to pay an emergency award. And then there's also concerns about enforceability because it's included in the restraining order, but it's not a money judgment. And Oregon law provides that you can't enforce an order simply for the payment of money through the contempt process. So as a result of all that, judges are sometimes reluctant to issue those orders, some more reluctant than others. It's not requested that often, and it's ordered here pretty rarely. Judge Tepper, what do you want to say about that?
Well, of course, our law is quite different in Florida, and I would urge you all there is the ABA a Commission on Domestic and Sexual Violence had done a survey on why in Oregon it wasn't done, and obviously the law is what guides you, but, I believe that judges ethically have an obligation to participate in improving the administration of justice. And
yes.
I know in our state we can, with the permission of the Supreme Court, communicate with the legislature on any proposed law changes. And I would urge you to think about this, and I'm surprised that any of your statewide domestic violence organizations haven't. But in our law...
Well, I just want to jump in and say, I would say that's not exactly the accurate about how the decision not to include support in restraining order proceedings here went down. Just one thing I want to note is that one concern I think expressed by advocates for victims in that process was in Oregon we don't have automatic hearings on restraining orders. We only have them at the request of the respondent.
I was surprised to see that.
So the vast majority, I think we're maybe the only state in the country, so the vast majority of restraining orders there's never a request for a hearing by the respondent, and one of the concerns discussed at the time the decision was made not to include support was that including support would greatly increase the number of hearings requested in these cases. And generally speaking, victims really don't want to come to court to have to defend their restraining order if they don't have to. It's a stressful experience, and it puts them in contact with the respondent, and there's lots of reasons why they find that unpalatable. So what Oregon decided to do instead was to beef up its administrative side proceedings to make them more accessible rather than including them in FAPAs. But there's lots of other things too. But I also understand you guys do it differently. So let's hear more about how you do it.
What we do, we approach it from multiple ways. Number one, our statute does permit potentially an indefinite injunction, and we have many types of injunctions: sexual violence, domestic violence, repeat violence, stalking, dating violence, sexual violence. And not all of them, of course, would have monetary impact. And we only can issue an injunction ex parte for a period of 14 days unless there is good reason to extend it, for instance, non-service or by agreement with both sides. And those temporary orders do not have any monetary impact except perhaps return the automobile unless they can produce proof they own it, return the car keys, etc. So on a return hearing, and by the way, over the years, because again, I've done this for so long, once the petitioners could see that, number one, we have a strong victims advocate that's allowed to sit in court with them, and our legal aid society will sit with people that qualify and assist them, we have a significant number of petitioners that do come to court because they do want to discuss child custody, they want to discuss parenting time, they want to discuss the money, etc. And so we do have hearings, but I find that most of my cases actually don't have contested hearings because I explain to them what we can do, and we usually can reach an agreement, but I also bring them back every approximately 45 days to see if they've done batterer's intervention because I want this to end. I'm allowed to do that if there's mental health issues, trauma. They're coming back in, and are you paying child support? Now, with regard to the child support, and I looked at all the survey information on the ABA, as an example, they have to fill out a financial affidavit. A petitioner does when they file, and it's pretty straightforward. And when they come, if the respondent comes to court, we may just ask what your income is. And my office we have a very quick child support guidelines form that my assistant fills out, emails to me. I have it on the bench. It already has it plugged in, what the income is, the net income, the child daycare, and how many children. And then I'll ask the respondent, I'll plug it in, I get an answer. But I also have already prepared what it costs if I impute minimum wage on one child, 2, 3, 4 children. And I also can ask if there's other children and other child support obligations. It isn't that complicated.
Okay.
I can do it in a matter of 3 minutes. And then I also find our clerk pulls all related cases because there could be a Department of Revenue case out there. There could be another child support case where a different number is in place. We want to adopt that or order them to pay it. Or sometimes the DV results in a change in custody. We don't want somebody to lose their license because they don't need to do that anymore. But it's not that hard, actually.
Okay, and I appreciate that, and it's very exciting that there's lots of different ways to approach this that keep victim economic security and independence, first and foremost in mind. So information about Judge Tepper's process and how they do things there is available from her and through Judge Orff if people want more information about that. We're going to move on because we have a lot of territory still to cover. I just want to quickly mention that there are other types of protective orders in Oregon, including the Sexual Assault Prevention Act. That's a relatively new statute. It does talk about other relief necessary to provide for the safety and welfare of the petitioner. It doesn't mention economic relief specifically, but arguably that could be an option there, although there isn't any really case law yet detailing whether that's a possibility. Civil stalking orders in Oregon are also available, and they have specific damage provisions, and so the details of that and the statutory sites are set forth on the slide that you see before you now. Also turning to the Elder Abuse, I'll just say Elder Abuse and Disabled Persons Prevention Act because the actual acronym is so long I always have trouble saying it. But it also provides another relief provision. It doesn't specifically provide for economic relief, and there's almost no case law interpreting this particular type of restraining order statute, but arguably some form of economic relief might be possible in the context of an order like that or provisions designed to prevent economic abuse. So turning then now to getting to some more specific criminal issues regarding pretrial and pretrial release, Judge Tepper, do you want to talk about how you handle that in your area? About criminal defendants on pretrial release or bail?
We have a statute that talks about a wide variety of things that we can and should do in terms of no contact, but I find that the more specific we are and upfront we are, the better. One of the key things is to make sure that if we are going to do a no contact, we are clarifying what no contact means, and that we are making sure that the address that is the arrest sheet is not the address that we've just told them they can't go. And I make it a condition of they either tell me a different address or it's a condition of their bond that they provide a different address. And if we have a place of employment and things like that, we might want to add that even if they haven't gotten an injunction yet. You won't, go within 50 feet of the named victim. I find that is quite helpful because we don't want the unanticipated loss of income because they were afraid to go to work. It's a problem where you have people in the same employment, but that can be addressed as well. And I think, as you can see from the slide, other things that need to be addressed for safety.
Okay. So turning to the question of encouraging victim participation. So just by way of introductory statement there, and then I'll turn it over to Judge Tepper. It's an interesting question what the role of the court should be in encouraging victim participation in various processes. There is a line there that we all have to be thinking about between providing information to everybody and then advocacy on the other hand. And so I think judges probably draw that line different places, but it is a potential perception of fairness issue that we have to be mindful of. Judge Tepper, what do you want to say about encouraging victim participation?
Well, we have to make it possible. I try to make it possible for not just victims, but even defendants to appear. I always ask how they're getting to court. Do we need to schedule it for a different time? And we can't expect them to participate if at the same time they're putting the children on the bus or taking them to school or getting to daycare, or if we could just and our calendars are limited, but sometimes we have some flexibility, and that is key. And as I'd earlier said, connecting them with the resources in the community so that they can avoid it costing too much for them to come to court. Those are some of the things that I try to make sure they do. And I also want to urge that getting law enforcement to upfront see what's going on when they go out there for the arrest so they can make all of those charges. They can seek restitution for the phone that was broken, the TV, et cetera, so that they're not having those added problems.
Yeah, and additionally, I think it's very important to make sure that information about resources to both sides, both a person who's experiencing intimate partner violence and a person who may be using violence in an intimate relationship, that information is available to all of them about resources that might improve their situation, including resources for counseling, treatment, and intervention.
And I give out on a regularly to both sides information on where they can go to get a shower, where they can go for a mobile medical, where they can go to a homeless shelter, where they can go for a hot meal, where they can go to a food pantry.
That's all very helpful. And police in Oregon deliver information about victims' rights and resources to victims and survivors of domestic violence on scene when they respond to incidents of domestic violence. And they now have, in some precincts, advocates who go out with the police to respond to domestic violence events, which has been more common, I think, around the country, less so here, but it's a growing program here in Portland anyway. Do you have that in your jurisdiction?
We've had that for a number of years now. It's been very effective.
Yeah, the other things that I think judges need to be aware of is just keeping an eye out for attempts at, I'll call it financial coercion or abuse during the course of proceedings, because that can happen, and if it's brought to the court's attention, then it needs to be addressed. And I can't say much more in detail about that because how that might arise in a particular situation is really going to depend upon the facts of a particular case. But it is a feature of the power and control dynamic present in domestic violence to use economic coercion and punishment as a way to exercise power and control. And so if we see it happening, we need to find a way to, within the bounds of our authority as judges, to stop it from happening. And that can include forms of witness intimidation and making it difficult for witnesses to get to court. We obviously are not in an investigative role in those situations, but when it's brought to our attention, then we need to think about how we can prevent that from happening because that's not fair. Judge Tepper, any thoughts about that?
Yeah, again, I try to be upfront with, if it's a defendant or a respondent, to let them know this is if you violate this is what can happen. Your bond can be revoked. You can be arrested for a separate crime, a violation of an injunction or violation of a pretrial release. And that's why I want to make sure you understand this. There's no reason for this to be violated, no reason for you to do that. That helps. And, again, it's trying to show balance, but that there is a consequence if you violate that. In the question of in essence, the indirect financial intimidation, it is, of course, a separate crime, a very serious crime in Florida to intimidate a witness, and I try to tell them that up front before it happens so that doesn't happen. Because of all of the electronic changes, there can be significant economic impact because of hacking and accessing accounts, their social media, et cetera, and causing somebody to lose their job, causing somebody to have money withdrawn from their bank. And all I can suggest is that we make sure that our local providers are educating victims on that if we have the ability to detail our orders to say no texting, no accessing, no posting, et cetera, to, about, or pictures of somebody, it also helps mitigate the likelihood somebody will lose their job or somebody's going to get a new charge. That's all we want to do.
So let's talk a little bit more about sentencing. We've talked a fair amount already about restitution and crafting orders that are specific and realistic and making sure we have all the information that we need to make good orders that impact restitution to victims and considering probation conditions that relate to economic security. We need to be sure, and we're required by law to allow victims to be heard at plea and sentencing, and I would submit that we need to give them an environment in which they feel safe and protected in order to be fully heard on this issue. I think, in my view, that includes being flexible about the mode of their appearance, such as allowing them to appear by phone at times if they feel that's necessary for their safety, and just asking open-ended questions to ensure that we're really thinking about their needs in sentencing. Much of that will be negotiated in cases through plea negotiation, but we still as judges are not rubber stamps of plea negotiations. We need to be sure to hear from the victim and make sure that we're doing the best we can to make them whole to the extent we can under the law. Another thing I want to mention is that it can be very complex having a family participating in multiple different types of court proceedings in a court. And we do our best to try to have a one judge, one family system. Judge Tepper, I'll let you talk more about your court's approach to that because I think it's more unified. But I do want to say that with the advent of Odyssey, and I believe all counties in Oregon now except for maybe one are Odyssey courts, we should be able to do a better job of knowing what other court processes families are involved in and being aware of other court orders so that our orders harmonize with one another and making sure that the right hand knows what the left hand is doing and that we're not entering inconsistent orders across case types. And so that includes, as mentioned here, restitution, civil protective orders, no contact orders in criminal cases, but it could also include juvenile dependency cases. It could include family court cases such as custody and parenting time or dissolution cases. So we have to just remember that we want our orders to make sense to the families. Judge Tepper?
Yes, in Florida we have the Unified Family Court, but it's very strong, and the presumption is that you should go to one judge unless you can establish a reason not to go to one judge. And we have over the last 15 years been refining that to assure that if it's possible, cases will automatically be reassigned to the judge who has the most experience with the family. Criminal cases can be a little bit different, but even I get some of the criminal cases related to some of my family's independency, domestic violence, and delinquency. However, it isn't as hard as it gets if you have strong relationships with the clerk's office, with the state attorneys, with the public defenders, with the bar that specializes in family. And we have forms in Florida that mandate, whether you're represented or unrepresented, you notate all of the related cases. In addition to that, our clerk, because of a positive relationship I have with them, they will automatically, if I get a domestic violence injunction to review, no matter what case I have, they are sending me the dockets of all of the related cases so I can see, oh, we just had a temporary hearing in divorce, and now we have a DV that seems to be wanting to undo that. And then I will pass that case on to the family judge, and our administrative judge will automatically assign it so we don't have conflict, we don't have repetitive hearings, and we don't have inconsistent evidence. In addition, the very simple thing to do is always to copy my order to a related case, and that helps as well, to copy it to the state attorney, to the family law case or the Department of Revenue, and that helps a great deal.
This is the type of case, domestic violence cases generally are the types of case where problems and abusive behaviors can thrive when they are not being responded to in a coordinated way. We all know the importance and value of a coordinated community response, and it should include a coordinated court response as well, where people don't fall through the cracks because the right hand, again, doesn't know what the left hand is doing, and that just opens the door to manipulation.
I will even tell the defendants, I go, look, I know you think we talk to each other, but we don't. And you have a criminal judge that's doing your domestic battery, and they're going to order you to do the batter's intervention. I'm ordering it because in this domestic violence injunction, and yes, one time counts, but we don't know that you're doing it in each case. Please make sure that it is your proof is going to both courts, so there isn't a misunderstanding.
So let's turn to the issue of enforcement. So we've talked some already about probation reviews. And so, Judge Tepper, just briefly, I understand that you have a pretty robust practice of scheduling probation reviews in all domestic violence cases. Is that true?
Yes, and I'm the queen of forms. We have orders to appear, and because we've chased people over the years, and because our DVs last so much longer, what we do is I serve them in court on the return hearing with the next time they're due, if there are obligations, if I'm going to be review parenting, if I'm reviewing batter's intervention or substance abuse, and then they know. If they don't show up for that, we'll have them served with it at the same time. And then I check off whether they have to appear or not. Do we have to talk about what that evaluation said? Do we need to review visits? And again, I'm always telling them, if they're in court, this isn't set in stone. My goal is to maximize your time with your child. My goal is to assure safety, but I need you to come back to court. I don't do contempts for failing to pay child support unless I have an affidavit, but that's a whole other story than you have. I find it to be so positive. They get so much out of it, and we're not chasing them, and we don't have 6 cases for one family because it got resolved without anybody resolving the underlying issues.
So let's talk about the issue of developing policies and protocols which help support and enhance victim safety and overcoming economic dependence and economic victimization. So there's a lot of different ways that can be done. You've heard a lot already about types of forms that Judge Tepper has found to be effective to help accomplish this goal, the setting of hearings and the scheduling of hearings in a way that help enhance the goal here of economic safety and independence. Also, I'm a very strong advocate of the importance of judicial leadership in education and training. And I think judges vary in their view about the role that the judiciary should take in that. And I am on the end of, we have a tremendously powerful ability to get people to the table to talk about how to make the system work best for everyone. I definitely believe that, it's sort of like if the judge sets the meeting, they will come, and they really will. And I find over the years that I've learned that the best decisions and the best processes get built by a collaborative process where all voices are at the table, including people that are viewed historically as opponents, because what we find is that we often have common goals. We usually have common goals, and having lots of big brains around the table with different perspectives, including the defense bar in these cases, is really, really important. So I really do believe that we should be leaders in bringing people to the table to help accomplish the goals of justice for defendants and for victims. Judge Tepper, what do you want to say about that?
I wholeheartedly endorse what you just said. And we can be conveners, and indeed, when we have a meeting, they will come if they feel that they are truly being heard. And I know whenever I have changed divisions in anticipation of it, I will invite all of what I call the stakeholders to participate. What do you need in your scheduling of the docket? What is going to meet your needs? And then everybody will be able to be the best that they can be, and they may have excellent ideas. And for those, where we have community resources that can help, they are invited as well.
Agreed.
And I used to want to, kind of yell and scream, not really, but that was a long time ago. And instead, I have collaborative, wonderful relationships with all of the various stakeholders, and that is the best way to problem solve instead of just ordering things around. There may be very good reasons why things aren't happening, or they didn't realize it. So knowing that you can have a voice and be heard makes a difference. Your leadership sounds superb, Judge.
Well, I really believe that people who come together with an expectation of good intentions on all people at the table and a desire to do well, who are willing to engage in a process of non-defensive self-examination and a desire to work towards the good of the overall system, results in really, really, really good processes. And it can't just be a one-time thing either. And this goes not just for developing new processes, but training. It has to be ongoing, and it has to be informed by what's new and great in terms of understanding of best practices and practices in other jurisdictions that might work well. So I think we as a judiciary should commit to doing our best to constantly support education, training, and bringing the level of our practice up to the highest possible level, because these cases particularly are ones which, I don't mean to be dramatic, but quite frankly can be of life or death seriousness. They really can be. And so we all owe it to bring our A game to doing the best possible job possible for both defendants and victims in these cases.
And what I have found, because of the Project One, I was driven to create meetings. We don't do it every month, but 9 times a year, the stakeholders, which are vast in the community, come together, and I'm always asking for people that want to share information. We didn't know that this existed or that, or how this works, whether it's a housing issue or whether it's a health issue or whether it's a batter's intervention or an innovative parenting program. We will bring somebody in to educate us, and we all learn, and then we share it electronically. And all of us coming together, and then they are forming separate relationships that never existed before, and then people they're not in contention with one another. We're getting the right quality of services for the right people, because this is going to matter for the next generation as well, be life or death for this one.
I agree 100%. Malore, do you want to kind of wrap us up?
I would love to. Thank you so much to both of you. That was such an inspiring and riveting conversation, and you both have so much wealth of experience and knowledge to share. So I hope our audience members felt the same way. Before I let you all go back, I know you're all busy and probably have court hearings in just a couple minutes, but I just wanted to mention we have a number of resources directed for the justice system in general and courts specifically on our website. We're actually working on modifying our national judicial bench cards to be organ specific with existing statutes as well as common practices in Oregon. So hopefully that will be released in the next, the summer or fall maybe. We will be sending out the presentation as well as a recording that will be up on the internet link that we sent out in the next couple weeks. And with Judge Tepper's permission, we can also post some examples of the forms that she's mentioned.
Happy to.
Wonderful. So With that, here is my contact information, and we're happy to direct any questions or comments you have to the right people, and you can always feel free to contact Rebecca Orff as well. Becky, did you have any last-minute notes?
I was just going to add that if people do have questions, since we haven't had time to really address those, please feel free to send those to me. It's Rebecca Orff, ORF, and then the OJD directory. So, and I can follow up on those or get them to the right person. Thank
Malore,
you to everyone.
Yeah, and Malore, thanks for hosting. Judge Tepper, thanks so much for your participation, and also Judge Orff, thanks so much for being our organizer and conduit.
Oh, thank you all. And just to let you know, we will be applying for CLE credit for this, and everyone who registered will get that information.
All right. Thanks
everybody.
Everyone.
Thank you.
Thank you, Sarah.
Bye-bye.
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 Thank you,